AI hiring bias. Europe built a law. America fought one. In May 2026, something strange happened. The European Union had spent years building what many people called the toughest AI law in the world, a law designed to regulate the exact kinds of algorithms that increasingly influence who gets hired, who gets promoted, and who gets approved for a loan. Then, just months before its most important provisions were supposed to take effect, lawmakers voted to delay them, not kill them, not weaken them, delay them, by 16 months. At almost the exact same time, the United States was moving in the opposite direction. Rather than preparing to enforce new AI accountability rules, the federal government was supporting efforts that would make it harder for states to regulate AI systems at all. Two governments, two very different philosophies, the same technology, and surprisingly, the same outcome. Because if an AI system rejects your job application today, whether you're in Europe or the United States, the question is still largely unanswered. Who is actually checking whether that system is biased? That's the question this video answers. And the answer is a lot more complicated than the headlines suggest. If you watched my last video, you'll already recognize the pattern. We looked at Pymetrics, one of the most widely used AI hiring assessment platforms in the United States, now owned by Harvard. What made that story interesting wasn't simply that companies were using AI to evaluate applicants. It was how the system worked. Scores generated from one employer could be reused by other employers using the same vendor. In some cases, those scores remained active for up to 330 days. Researchers studying the system discovered something unexpected. When they examined hiring outcomes at a high level, everything appeared relatively normal. But when they analyzed results position by position, a different pattern emerged. Applicants rejected by one employer using the platform were significantly more likely to be rejected by another employer using the same platform. The concern wasn't simply bias in one hiring decision. The concern was the possibility that a hidden pattern could propagate across multiple hiring decisions while remaining largely invisible. Colorado attempted to address this problem. The state proposed one of the strongest AI accountability frameworks in the country. Then it ran into lawsuits, political opposition, legislative revisions, and delays. By the time the dust settled, the law had been significantly weakened and pushed into the future. That was the American story. Today we're looking at the European story, because Europe appeared to be doing something completely different, at least at first. In 2024, the European Union passed the AI Act. This wasn't a narrow law focused on a single industry. It was the first comprehensive attempt by a major government to regulate artificial intelligence across the economy. The basic idea was simple. Not every AI system creates the same level of risk. A movie recommendation algorithm isn't the same thing as a hiring algorithm. A chatbot isn't the same thing as software helping determine whether someone receives a mortgage. So the AI Act divides systems into categories based on risk, and near the top sits a category known as high-risk AI. This is where our story begins. Because the systems most relevant to ordinary people ended up on that list. Hiring systems, resume screening systems, candidate ranking systems, employee evaluation systems, promotion systems, termination systems, and credit scoring systems. In other words, some of the most important decisions in a person's professional and financial life. The European Union looked at those systems and essentially said, if you're going to use AI to influence decisions this important, you need to prove the system is operating responsibly, not assume, prove. And that's where the AI Act becomes genuinely significant. The law doesn't simply require disclosure. It doesn't merely ask companies to admit they're using AI. It creates ongoing obligations. Article 9 requires a continuous risk management system, not a one-time review before launch, a continuous process. Article 10 requires companies to document training data and evaluate it for bias, not just claim they tested for problems. Actually maintain evidence showing how those tests were conducted. Article 11 requires extensive technical documentation. Enough documentation that regulators can evaluate a system even if they weren't involved in building it. Article 14 requires meaningful human oversight. not a ceremonial human sitting in the loop, a person capable of intervening and overriding the system when necessary. And before many of these systems can even be deployed, they must be registered. The result is something much closer to accountability than anything currently operating in the United States. Then there's the enforcement mechanism, because regulations only matter if violating them has consequences. For the most serious violations, penalties can reach up to 35 million euros or 7% of a company's global annual revenue, whichever number is larger, 7%. For a multinational company, that's not a fine you casually absorb. That's the kind of number that gets boardrooms paying attention, which is why, for years, companies preparing to operate in Europe had a date circled on the calendar: August 2nd, 2026. That was when many of the most important requirements governing hiring and credit scoring systems were scheduled to become enforceable. Everything appeared to be moving toward that deadline. Then the deadline moved. In May 2026, European lawmakers agreed to postpone enforcement of key high-risk AI obligations, not by a few weeks, not by a quarter, by 16 months. The new target became December 2027. At first glance, that sounds like a major retreat. But here's the detail that makes this story more interesting than a simple narrative about regulators backing down. The reason for the delay wasn't primarily political. The reason was infrastructure. The AI Act doesn't just say companies must comply, it requires compliance against technical standards. Those standards help determine how systems are evaluated, how audits are performed, how conformity is measured, how regulators verify compliance. The problem was that many of those technical standards weren't finished yet. Imagine being told you'll be tested against a rulebook that hasn't been fully written. That's essentially the situation regulators and companies found themselves facing. The law existed, the enforcement framework existed, but parts of the technical architecture needed to make the system function weren't ready. So European lawmakers faced a choice: proceed anyway and risk inconsistent enforcement across 27 countries, or delay implementation. And for the American applicant, existing anti-discrimination law still applies. Civil rights protections and employment law still exist, but there is no comprehensive AI-specific federal framework requiring ongoing bias monitoring, recurring audits, technical documentation, or proactive risk management for hiring systems. The applicant receives fewer AI-specific protections, and those protections often activate only after harm has already occurred. So now we arrive at the central paradox. The European applicant has stronger rights, but many of those rights remain delayed. The American applicant has fewer rights, and many of those rights were never created in the first place. Different roads, same destination, at least for now. There is still no jurisdiction actively enforcing the kind of AI hiring accountability framework many people assume already exists. But before we call this regulatory failure, both sides have legitimate arguments. Europe's delay wasn't irrational. If the standards required to evaluate compliance don't exist yet, rushing implementation creates inconsistent enforcement. Companies end up guessing. Regulators interpret rules differently. A delayed system that functions properly can be better than an immediate system that functions poorly. Likewise, some American concerns aren't purely ideological. A company operating nationally could face dozens of different regulatory standards if every state creates its own framework. That's a legitimate compliance challenge and a real argument for a national standard. Both perspectives contain truth. Neither changes the reality facing ordinary people today. If you're applying for a job in Berlin this month, no regulator is actively auditing every hiring algorithm on your behalf. If you're applying for a job in Denver this month, no regulator is actively auditing every hiring algorithm on your behalf. And that's why the story matters. AI isn't waiting for lawmakers. It isn't waiting for standards committees. It isn't waiting for court cases. It's already here, already being deployed, already influencing opportunities, careers, and financial outcomes. The real question isn't whether AI will be regulated. It's whether regulation can arrive before these systems become too deeply embedded to meaningfully challenge. Europe built the strongest AI accountability framework we've seen so far. then discovered that building the infrastructure to enforce it was harder than writing the law itself. The United States never reached that stage. Instead, it became locked in a fight over whether those regulations should exist at all. Two governments, two different philosophies, two different obstacles, and one surprisingly similar result. The algorithms are operating today, the oversight mechanisms are still catching up, and until that changes, the reality remains the same for the person submitting a resume and wondering why they never got the call back. Because somewhere behind that rejection may be an algorithm. And right now, whether you're in Europe or America, the systems designed to hold that algorithm accountable remain a work in progress. Drop a comment below. If you're outside the United States, has the AI Act actually changed anything in your day-to-day life? Or does it still feel entirely theoretical? And subscribe, because this story isn't over. I'm going to keep tracking 3 things. What happens when the EU's December 2027 enforcement deadline finally arrives? What happens to Colorado's AI law when it takes effect? And what happens in Texas, where lawmakers quietly changed the standard from discriminatory outcomes to discriminatory intent? Because the biggest AI story isn't the technology anymore. It's who gets to decide the rules.